provision under the notification, the eligibility provision at 10, and then at 11, that how that was valid for a period of 7 years, because there is going to be a change in the requirement of the qualification. However, that's now done for lifetime, so I must bring that to my Lord's notice.
But that clause says maximum 7 years.
Yes, my Lord. But it is now
And they change.
NCT has changed.
Yes. NCT changed.
Yes, my Lord. The NCT has changed it, so therefore I cannot do anything about that. Yeah. But it also notices that there should be a TET exam once in every year. And it is an...
And you know the interpretation of this survey is discretionary. You know this. Because in all the so many cases of this coding,
Please, my Lord.
where this issue has been considered that the case of the promotion shall be considered
Yes.
on year-to-year basis.
On year-to-year basis.
That we interpreted so hardly.
Yes, my Lord. My Lord, I'm not on that aspect. My submission is something slightly different. I say while it is recognized that the exam should be held year on year, it's also an admitted position that between 2016 and as on date, exam has not been held. So it is the background on which I wish to make my submission. I'm on that particular aspect of the matter. Now, my Lord, what I wanted to show was that the state had the discretion to consider the candidates who had obtained the TET certification. The state does have that discretion under that eligibility test 10, which I have shown yesterday to my Lord. My Lord, I want to state that there are 7 states which have accepted CTET as a qualification. Yes. Can you get more for 7 states?
How will it be beneficial here in this point?
My Lord, it will be beneficial.
Taking the law.
Absolutely. My Lord,
How it is beneficial?
it will be on the aspect that the state does have the power to accept CTET as one of the
That power that is under the law. We show that. Then that not take then whenever they challenge to it, then we look into.
My Lord, that my Lord
Is really a point of discrimination, no?
my Lord,
I did not at all you see ever see that.
my Lord, it's my plea in the writ petition. It's my plea in the writ petition.
So that
Yes, my Lord.
is free of
Yes, my Lord.
discrimination.
No, I have taken a plea that said CTET be recognized.
He recognizes a different thing.
Yes.
What point you want to converse here is that out of 48 states in India, in 7 states, state government has notified this.
My Lord, I wish to...
What we can presume is that
No,
you want to take a plea of discrimination, that once it is being adopted in the state of Jharkhand, there cannot be any arbitrary exercise.
No, my Lord.
What we are thinking of.
Yes, my Lord, I'm sorry that I did not complete that particular aspect. My submission is slightly different, my Lords. My Lords are right, it can be looked as discrimination, but that's not what I'm submitting. I am saying this, that there are states in the country which have accepted CTET as being one of the minimum qualifications. I'm not saying on a principle of discrimination, because it will depend from state to state whether to accept or not to accept. What I am trying to say is that CTET has definitely come to be recognized by the states as one of the minimum qualifications for the purpose of consideration of appointment to the post of a teacher, where states may not have conducted the exam. For example, in Assam also they had not conducted the exam. They accepted the exam. My Lord, it works.
Discretion.
The state here also exercised that discretion is what I am trying to say.
It was exercised.
My Lord, I'm going to answer that. Just give me 2 minutes.
This is the only point there.
My Lord, that's
The point here.
yes.
Suppose we are
Yes.
coming to the guidelines to understand applicability.
Yes.
Then the guideline specify a specific procedure.
Yes, my Lord.
And in terms of that procedure, you can adopt. We are not going to answer and mark upon that the state is authority or not. But at present, we have to say this much, that in the circumstances in which that can be adopted.
My Lord, I will answer that.
Please answer this much only. I will is the crux of the matter.
I will come back to this particular point. Please allow me later, but since my Lords have put a question to me, I must answer that straight away. Can you pass that note down? My Lords, that's on a position of twofold that my Lords have put to me. One is the change that has been carried out in the advertisement That's one aspect that my lords are looking, and the state having done that. My lords, there are two facets. Now, I wanted to place before my lords that these particular writ petitions, which I want to say, have been filed. My lords, they have been the first writ petition. Would my lords see my paragraph D on this? We just put a small note together, my lords, on the factual aspects at least. The first writ petition before the High Court came to be filed on 7th of November 2022, which is the Suraj Bihari Mandal petition. After that, petitions came to be filed. There are 4 of them here, and the last one on 8th of May 2023. In 18th of May 2023. In all these petitions, there is a common prayer that the state has not held CTET, so please recognize CTET. Now, my lords, please, one thing I must make out here very clearly. We are all residents of Jharkhand. We have gone and taken our exam, either the CTET exam or in the neighboring states, while the state of Jharkhand was not conducting the exam. So that is an important facet, that we are all residents of Jharkhand. We do know the local culture, languages, etc. from Jharkhand, and that's also pre-qualification that the state has now put, even by granting that little relaxation. Now, my lords, this particular advertisement came to be issued on 19th of July 2023. That is advertisement number 13. This, my lords, will find the date in the counter. This has been mentioned at page 1, number 169 of additional documents, that this advertisement is dated 19th of July. In the interregnum, my lords, when these writs had been filed, counter had been filed by the state of Jharkhand, the advertisement came to be issued. What I'm laboring now to point out is, between the judgment of the High Court and the amendment made subsequently to the advertisement, the state of Jharkhand had itself carried out at least 6 or 7 amendments to the advertisement, extending the time for filing an application, extending the age limit, and other concessions to the same advertisement. So, my lords, the extension which was granted after the judgment of the High Court was not the first extension for the purpose of filing of the applications. So, on that aspect, where it has been stated, so, my lord, please, there is a small series here. If I may just quickly run this.
Is not much relevance.
My lords,
Madam, we are asking only one question.
please, my lords.
Please apprise us on the facts of the case
I am.
that as per clause 10
Yes.
of NCTE guidelines,
Yes.
when the exemption can be granted, and this procedure has been adopted. And in fact, this was the work of the state government. State government was not in a position to discharge this onus.
Please, my lord.
We have already heard Mr. Maninder Singh as well as Guru Krishnamurti. Even both of you are one of the
viewers' query that my lords have put to me first, and I cannot put it beyond that.
whatever you want
Yes.
to do it. We
So, my lord,
have already given you half an hour.
my lords, I will stick to the timeline that my
We
lord
have already spent.
My lords, I will try.
We have given today. Otherwise, you would
My
have.
lords, please, I would submit this, that it is within the power of the state of Jharkhand to amend its rules to bring in CTET as one of the qualifications. As of today, there is an amendment. The rules have been amended, which have been amended as on January 2024.
29 January.
29th of January, I'm grateful. Once the rule has been amended and the said rule is not a subject matter of a challenge, it definitely cannot be challenged by way of a side wing by filing an IA in this particular petition. For the purpose of challenge, the necessary process has to be followed. That has not been done. Once the rule occupies the field today, unless and until that rule is set aside by a court, my lords, in a this will be my submission. My lords, that rule today operates. I come to the second limb. There is no challenge, so the rule does operate, and the rule recognizes CTET as one of the minimum qualifications. Number 2, the rule is under Article 309. Again, this is my first submission. My lords, my second submission to my lords is the submission that the rules of the game have been changed after the game has begun. Because if there is an occupied field and there is a legislation or a rule today that prescribes CTET as a qualification, I will place before my lords the material to show that it cannot be said that given the advertisement of 19th of July 2023 or that the rules of the game have been changed or it has inured to the prejudice of the other party, to the petitioners here. And I submit this for a reason that by a line of judgments my lords have held that the commencement of a process would have happened if the exam had commenced or the parties had participated in an examination. Here, on 19th of July, when the writ petitions were already pending before the High Court, only an advertisement was issued. First of all, there was a pendency of the writ petitions. My lords, my second submission is that while an advertisement was issued on 19th of July 2023, pending 4 writ petitions on the issue, the state itself chose to make at least 6 amendments, whether it was an amendment in the state. Yes, my lord, I have given out a list also to accommodate various persons, which is set in this particular note. Now, and the state also extended the time prior to the judgment of the High Court for as being the last day for submitting of applications. And this is until the judgment of the High Court. So the state...
Not like then. The time was extended. But it is after the judgment of the High Court.
No, my lords, it had been extended even before. This is here. My lords, it is here. I have put the number of notifications. Yes, my lord. Yes, my lords. My lords may turn to bottom of the page, the first amendment, age relaxation. Then, my lord, name change. Then, my lord, please turn to serial number D. Serial number D on the page number 2.
Yes, serial number D.
Yes, my lord. Extension 1. 8th August 2023. Before the judgment of the High Court, online form submission deadline was extended to a new period from 16/8 to 15/9. Then, my lords, the next extension, my lords will find at serial number F. This date 6/10, which was the last date given previously.
Relevant for us. We are only concerned only on the point of CTET educational qualification.
My lord, so I would...
Please, madam, please refer that.
My lord, I am on that aspect. I say...
Come on then.
So...
When it was extended.
Yes.
What is this writ petition 4049 of 23?
My lord, that is...
Not mentioned in the list. Because this is in reference to some writ petition. There is...
My lord, these are those para teachers. That is that writ petition. That is where that order came. It was shown to my lords yesterday. So we just put it there for the purpose of completeness. No, my lords, just give me a time to formulate this particular issue. I'll leave it at that. My lords, my submission is this.
We are saying directly come on the point.
My lords, I'm answering that point. My lords, my submission is this. When only an advertisement is issued and pre the judgment of the High Court, there has been extensions granted to that particular deadline for submitting an application form. After the judgment of the High Court comes, there is an extension that is then granted for the purpose of submitting the application forms. So everybody who comes into the zone of consideration with that extension of time that is being granted and apropos to that particular amendment that is carried out to the rule is eligible to participate in this teacher's appointment exam. My lords, having said that, once the rule is in place, extension having been granted of the deadline on which an application has to be submitted, we are eligible now to submit our applications to participate in the teacher eligibility exam because by virtue of an amendment to the rule, CTET has become one of the minimum qualifications or eligibility criteria to participate. But having said that, I would point out that this minimum eligibility criteria has been buttressed by the state. It is not just that. The amendment notes that in addition, I can participate in the exam subject to 2 factors. One, that I am a resident of the state of Jharkhand. Number 2, I have taken that particular exam either from an adjoining state or I have taken a CTET. Number 3, that I will at the first attempt also qualify the Jharkhand TET. So therefore, the state has
That
actually...
means they are not treating you eligible as
Manoj, they are.
provisional.
Manoj,
One. Number 2, you have given the list of amendments.
Yes.
The advertisement.
Yes.
Even the state is not arguing this. There is nothing on record here.
Manoj, these are...
One was the latest amendment which took place. Not later, she has given section 1 amendment. Not my learned friend. That is not even the stand of the state. Why can't I argue? Not up to argued. Where is the document on record? Only one document was shown. One document, not one. She has mentioned how much. That extension. One sheet was given to Lordship to the last extension. This is what the state is arguing. Last extension is up to 6th of April. We have to see all. What are the reasons for extension? And she is arguing. This is not even the stand of the state. But the stand of the state is this would extended up to 6th of April. Last is good enough. Look, I am saying that the list of dates is good enough. We are putting it in our note. The list of dates is good enough. Mr. Maninder Singh. Whatever of
Yesterday when the
is the way the state is existing.
argument was being once, your saying was last day was 6th of April.
I said
Not like this. Please, Mr. Maninder.
I am not.
We always remember the things well.
I am not saying
My right perspective.
I only have submitted that it not extended from.
All right, then please continue.
Now, if my lords will turn to the advertisement itself. The advertisement fixed certain qualifications to be attained as the date of the advertisement and for certain qualifications to be attained on the last date of online application. So far as the eligibility is concerned, or the CTET qualification is concerned, or TET is concerned, this will fall on the last date of the application as per the advertisement. My lords will find the advertisement in the additional documents filed by the petitioners at IA 3446. My lords, it is at page number, the advertisement starts at page
347.
Yes, my lords.
Yes, which page?
My lords may turn to page 149.
49.
Yes.
Yes.
My lords, I have put out a tabular chart for your convenience also at page 3, but please turn to the advertisement itself.
Yes.
My lords, page 149, please see the topmost serial number 1. It will be mandatory, my lords, have that? May I read? It will be mandatory for candidates to have passed desired minimum educational qualification by last date of receipt of application in the commission. Then the last date of receipt of application is 8th of April 2024. So I have to acquire a qualification which is now stands amended by the rules on 29 January.
Where is that other qualification?
Yes, my lords. Please turn to page 150 bottom. This is an experience. And for some purposes, they have done the date of publication, but for this, it is the last date of the application. My lords, page 150 bottom.
Experience would relevant.
My lords,
Purpose of the present case.
no, my lords, I am only showing that the advertisement is conscious on a fact that certain eligibility criteria or requirements are on the date of the application of the advertisement, whereas the purpose of this particular minimum educational qualification or the eligibility is on the last date of the application. My lord, those are two different things. Certain...
Please, kindly come to page 138.
Yes, my lords.
Intermediate named assistant teacher class 1 to 5.
Yes.
Fine.
Yes, my lord.
The last column, minimum educational qualification
Yes.
from institute recognized,
Yes, my lord.
in which a degree has been prescribed.
Yes,
then
my lord.
after
Or, and then there is the
and they have added and.
Yes.
So and would be part of the educational qualification then. If we look into like this.
So, my lords,
Then if we look into like this, then you kindly read one which you are reading.
Yes.
Educational qualification.
yes, my lords.
And kindly read this is prescribed. It will be mandatory for the candidate to have purchased the exact minimum educational qualification by the last date of the
Online
commission.
Yes.
In the commission.
Yes.
That is the last date of submission of online application form will be considered as the reference of form.
Yes, my lord.
Any candidate does not purchase the prescribed notice of
It will be considered ineligible.
By this date, he shall be considered considered ineligible.
So, my lord, my submission for your consideration is this: that on
That we have submitted after the extended date.
No.
Then the last date of submission of the form
Was
is whatever is invited you submitted on that day. If you have on the extended date, then within this clause, your qualification must
yes.
be dated.
My second link of that, my lord, there's one more link to that same argument, which is on 29th January 2024, by virtue of amendment to the rules, yes. So, my lord, my qualification,
your point. We have understand factual aspects. Come to the judgment if you want.
So, my lord, I also wanted to show that on other aspects they kept the date of the advertisement.
Madam,
This was the last.
We have already given you time.
Yes.
Our request is please kindly finish. Hearing that. We will not carry on this case after lunch.
My lord, I completely understand. Now, my lord, my three.
Like already you have already 20 minutes.
My lord,
That is why we are saying. And no fruitful point has come out by this time. Except to say this advertisement condition.
my lord, there is a legislation. I am on the legislation
We are
today.
not saying anything.
I am on the legislation today. There is a legislation by the state, my lords,
And please give
today.
Yes. We will take
Yes. Now, my lords, just give me the three judgments now. Just take out first bid and bid. Give me the judgments now. My lords, I have the judgments which have been set out on my last page. I want to copy the judgments of the court. Yes. My lords, the first judgment that I wish to place before my lords will be the 2011-12 SCC, page number 85.
These advertisements are prior.
In all these cases, my lords, the advertisements were dated prior and there was a revision that was carried out to the advertisement, and this court held that the advertisement, the exam on the basis of the revisions is valid and can be held. It will not amount to changing the rules of the game.
The question to that effect is, what was the change? Relevance of the change.
There were inclusions that were made here.
What inclusion?
My lord, inclusion of certain other category of candidates who will be entitled to participate. The competition was increased, just like in the present case it is sought to be suggested that competition has increased.
All right, fine.
Yes.
We will consider para 29 and 32 as you have stated.
Yes.
Yes.
Similarly.
And my lord, similarly, my lord will find in the other judgments.
Para 29.
There in the note. It's no relaxation. It will only be increasing.
My lords, in that particular paragraph, the court has held that consequently, may I read that part, my lords? In paragraph 29. Particularly, when a particular schedule is mentioned in an advertisement, the same has to be scrupulously maintained. There can be no relaxation in terms and conditions of the advertisement unless such power is reserved. And in this case, the advertisement reserves the power. I will show that particular provision, the advertisement has reserved it. Now, unless such power is reserved, such power could be reserved at the relevant statutory.
All right, we'll consider.
Panos, can I show the reservation of the power in the advertisement
Consider,
itself?
ma'am. We'll consider.
My lords, that,
Next.
my lords, can I show the
Next point, ma'am.
192.
my lords, may just take page 192 for a minute, please. My lords, page 192 bottom of that advertisement. And the whole advertisement has been subsequently modified at least on 8 occasions, my lords, before even the...
And we have said, please, go first.
My lords, bottom of the page. Yes, Commission reserves the right to change the schedule and the format of the examination due to unavoidable reasons.
Consider.
Then the document
Come to next statement.
Then, my lords, the point on... So, my lords, these three judgments are only on this particular aspect that an advertisement can be modified. There have been revisions to an advertisement and the court has upheld that. Now, my lords, there is an argument on the legitimate expectation that has been made on the other side. I would submit this that the...
I have only constitutional judgment.
My lords, that is that CT Shivakumar judgment that my lords are referring to. and I just want to point this out, that in a line of judgment, C.T. Shivakumar as well as pre and post, in the matters of judges' appointment cases and all, my lords have taken this particular view, that once an exam is held, the process has commenced thereafter, and if then a change has been made, it will amount to aspect of legitimate expectation. Here we are at a stage of advertisement, and advertisement
That will not attract.
that will not be attracted. That is my submission, my lords.
Yeah.
Now, my lords, the other aspect that I wish to, my lords, the issues which will then arise for my lords' consideration, please take that first paragraph on page 1, and I'll close with that.
First paragraph.
Yeah, the very first paragraph, I framed the issues and I put them in an answer form. My lords, the petitioners did not implead any of the 4 writ petitioners which were pending before the High Court. They have not impleaded any one of them. Now, so petitioners raise any grounds, my lords, the ground that has been raised today about the aspect that their rights are being affected or that this is a change of the game once the game has begun is nowhere there in the SLP. My lords, it's not there. It's not there. They have not taken the ground. And my lords, therefore, the pleadings get constrained to that extent. The pleadings can only deal with what has been asked. If a counter has to be filed, it will deal with what they have presented.
You know what you are saying? Did the petitioners raise any grounds as raised before this honorable court, before the High Court?
No.
So they were not a party in the High Court. No question of raising of them.
My lords, but at least the ground.
Up to next question.
My lords, but at least the ground. Now, this is very important. There is no challenge to the notification of 29 January 2024.
That you have said.
That I have read.
Consider this.
Yes, my lords. Now, my lords, the point is
That in advertisement they did so and so rules
attain their finality. My lords, that I respectfully submit. They attain finality after when they challenge this particular advertisement and they challenge the rules of 2022 before the High Court. The High Court rejected that challenge and they filed an SLP. That SLP has been dismissed on 9/9/2024. So therefore, those particular...
Just clarify.
Yes.
Whether this rule of 29 January 24
Yes.
or
That has not been challenged. That was not a part of that. I'll answer that.
The advertisement was.
Today also it is not a subject matter of challenge, that particular rule.
so that is not under challenge.
My lord, that
42 rules was under challenge, as you stated yesterday.
Yes,
I'm rightly remembering it. So that was against that petition was dismissed
yes.
and SLP filed at 2-1.
My lords, only one thing that I may add here for my lord's consideration. Advertisement number 13 was also a subject matter of challenge. On one hand, you rely upon that advertisement today to say that after the advertisement is issued, you can't change, there you have challenge. That is it.
Yes, go next.
Now, my lords, whether the petitioners have to, they disclose that they had challenged the same, my lords, I did that. That's a part of my first part. I will not deal with that. Now, my lords,
The petitioners have pleaded in SLP that they are challenging the amendments from
they have not pleaded. They filed an application. They filed an application, nothing more. So that is not under challenge.
so the fulfillment of eligibility qualification and
They are. Because this has been a
treatment.
my lords, the fact.
Petitioners were aware
Yes.
of the fact that fulfillment of eligibility of the qualification and on the last
Accepting,
application will be taken into consideration.
yeah. There should be last date of accepting the applications. My lords, this what I mean to say. lords, my learned friend corrects me on the aspect of the rules of 2024 amendment 29. He says that when the rules were challenged of 2022, they were challenged with the prayer of all amendments to date. And now when
rules were challenged,
my lords, they were
amendment or before the amendment?
my lords, they were challenged prior to amendment to date. But the SLP was filed in the Supreme Court against that. And therefore, always an SLP will be an extension of that, and all those amendments have to be considered. Yeah. My lords, they may not. But what I'm saying is, amendment to date is their verdict. Yeah. Yeah. My lords, I leave it there. But the last point that I was trying to make is that they had full knowledge that people had filed writ petitions, and the fact that there had been changes in the eligibility conditions consistently, even after the advertisement, including in January, and the exams were finally held on in April, May, and June. And the last date was 8th of April 2024. So they were completely cognizant, they had full knowledge about that. So this cannot be said that the rules of the game have. Very quickly the matter. I want to point that out that I have already pointed out that they had full knowledge. Now the three things that I want to state is that NCTE being the authority which has to provide the minimum qualifications in the matter of State of Bihar, which is before my lords, which my lords have kept it for after this or whenever. The rules are challenged. No, my lords there. The High Court has specifically issued notice to NCTE. NCTE before, and High Court records it in his judgment, said that it accepts that the states can take CTET as one of the qualifications. Now, Jharkhand has taken it.
Government says that.
Yes. So my lord,
There is a procedure in the state.
my lord, there is no procedure there in the sense there is no other procedure. It is for the state to accept or not to accept.
Right, but
Here, by legislation, state has accepted. My lord, I can't go better than that. Yeah, that I can't go better than that. So therefore, no, my lord, just two things more. Just let me just wrap it up. I'm wrapping it up. Don't stop, okay? My lord, my submission is this. Yes, my lord, it is going to be gift wrapped with a bow. My lord, my submission is that in the Bihar case where NCTE, which is the authority, academic authority, says CTET can be a qualification for a state, I would say they can't be better than that because that's the authority that decides. Number two, my lords, I have a comparison chart here about paper that was done of JTET in 2016, then the present JTET which the state wants to advertise, which exam has not been held, what is the syllabus for that, and the CTET. CTET is actually higher than 2016.
The state also admitted.
Yes, number one. Number two, my lords, I submit the languages papers are overlapping. Number three, I submit the languages that were taken by them in 2016 no longer exist in the JTET today.
Mention this in this, we'll consider.
My lords, this is not, I have a chart here. Let me just pass on this chart to you. And lastly, my lords,
We should dispense with filing the paper books.
yes, my lords, I agree.
These papers like
Papers being given, it is, I understand
this
because
system here.
No, it's a very situation.
Unique system here, in fact. Like playing cards, you one by one the cards come.
my lords, may only one thing I may say, and I'm not being deprecating or anything, but when the arguments are taken for the first time in argument, we are also on a,
Paper like this, how somebody will have time to respond to us.
Thank you.
so my lords, I have a last submission here.
Yes.
That when we took the exam for this particular post as teachers, at that point in time, we have taken the exam, it's unqualified. There is no interim order that was granted restraining us from taking the exam. The only thing my lord said was the declaration of the result. That's all. When we took our exam, no, my lord, it was not made subject to the outcome.
In any case, list fitness.
My lord, I am just saying this. And our qualifications are in fact much. My lords, can I have just one last line and I'll be greatly obliged for that? My lords, I have to take a JTET also. I have taken the CTET. I am a resident of Jharkhand and I still have to take a JTET and qualify.
For all, are you making this statement?
I beg your pardon, my lords, yes.
You making
My lords, for the petitioners before the High Court. For the petitioners before the High Court.
Uber Association?
My lords, no, they were individual petitions.
One man, one individual.
My lords, they were other petitions.
That man has already joined somewhere.
My lords, there are 4 petitions. There are 4 petitions. They're large number. Only one. Yes, my lords will look at the impugned judgment. There are 4 petitions.
But JTET also?
Yes, for
No, you are not J.
my lords, no.
You are saying that I am JTET also.
My lords, I am seated. There are others amongst us who are also taken the state text, which is maybe from Chhattisgarh or from Bihar, because the state was not holding anything.
There, no, that you are asking.
Yes, but my lords put to me for everyone,
Some of them may be seated, some of them may be stated.
and I am saying this statement for the petitioners. There are connected 4 petitions. Those are individuals.
Thank you, ma'am.
They are all individuals.
Thank you, please.
Yes.
Yes.
Just a few things, not taking much time. 2 minutes. My friends for today.
Thank you, within 5 minutes.
Not even. My friend said about your lordship also noted the 7 states have accepted. We do not know under what circumstances because there are cross-qualifying men.
We are not concerned in 7 states.
Then not qualification. My friend pointed out just one point that in the advertisement it says the last date of extension is the qualification.
Yes.
But here there is no qualification. How does it matter when the extension is also there? Still there is no qualification as per the advertisement. Assuming there is an amendment subsequently, the advertisement has not been amended. The extension is prior to the amendment. And the extension date is prior to the amendment of the rules. After the
What
rules,
is the law on that? What will apply?
Please, here is the point and you have to answer. Here is the point and still you have to answer.
yes, it does.
What they did is, advertisement was there, the initial qualifications have been specified.
I have said it.
Then thereafter there is a judgment. Alright, of the which you have challenged before us. Then they have invited the applications in the light of that judgment. The applications was invited in the light of that judgment of CTET persons. Absolutely. Alright. So once after this judgment, then they invited these applications, meaning thereby that CTET would be deemed to be included within that. And if it is included within that, and then we read this page 149, that on the date of submission of the application form, and this date of submission of the application form has been extended time to time. 1, 2, 3, 4, 5, and it is last is 6th of April 2024. So now, in that situation, and in the meantime, amendment in the rules has been made. We have not amended the advertisement, but because of the CTET, the applications have been invited, then this would be deemed to be a qualification within the meaning of advertisement. My humble submission, the last date would be 6th of April. The rules, what is your answer on that?
One, the rules are not retrospective. Number one, the rule doesn't say it is retrospective. Secondly, only when the state had the power to amend or include anything extra.
309 amendment.
What's the root of the matter?
309 amendment is not under challenge. This is the amendment of the rules.
Have in fact filed
Give aside 10 applications can't be to challenge the rules.
Your lordships are seized of the matter.
We can't say that.
For your lordships. Number one. Number two, when the judge
So point is of rule is not retrospective.
one. Number two, the judgment is challenged for your lordships. We are saying that relaxation itself is not permissible. 23(2) says when is the occasion that arises for a state to take a relaxation and include another qualification. It says appropriate government conducted TET. If you have the power, first of all, you have to satisfy that, and as 23(2) your lordship rightly pointed out. The third class
Is that a precondition for amendment of rules also?
No, that-
309, that's a statutory.
there is a relaxation of including CTET.
All right.
So that
we have.
that your lordship will examine. Then therefore according to us and on this. Then on the arguments advanced by Mr. Maninder Singh yesterday on the two judgments, they are not applicable. Actually, they are distinguishable. So I have put a note on that also. I am passing on my submissions as well, and they were not on the selection. They were only on the exam conducted for TET. There was no process started. There's nothing. So therefore, they are distinguishable on facts also. And 23(2) there has been no answer till now, And then my friend said a state government will mean any state government. So then we become superfluous than the enactment as such.
Even any is there.
Yes, Lord. Then there's no
Even any is there, but it would not partake the character of these states. You can understand?
Yes, that's all. Very well. I'll pass on.
It cannot partake the character of these states.
Yes,
A or any cannot partake these states. We can understand of this. Here state government, we cannot object the argument of the other state. We can raise the argument.
no, that everybody is entitled to submission.
My lords, on 15th of February 2024, advertisement was amended. It's in my note. My learned friend is not right that advertisement was not amended. It's in my note, 15th February. It is at serial number 3. It's in the note. And it is not being challenged. No, it's not. 15th February, it was amended. It is in my note.
There is no document on record for all this.
Because there is a notification of the government.
Keep it with you only. You keep all documents on you.
What do I do? It hasn't been. I can't.
It is not reliable. It is not with us.
It's a strange kind of a thing the case is being argued. This is what we have.
We are also handicapped, my lords, but the point is we have to bring it to my lord's notice. Finally, one.
What is the answer, Mr. Maninder Singh? How do we decide the cases like this?
Your Lordship, I can't have any anything against it. I vote
That is all. It would have been really strange. Never seen in more than 35 years the way the cases are argued here.
who have been filed along with the counter.
Never seen in High Court like this.
So Lordship is right. There is a miss on our part to play.
And state also behave properly there. Not like this. Right, then you fail.
Yes, please. The last prayer, my lords, I only request you.
See the way the cases are argued. Last court, this is the assistance we are getting.
Documents are now being given now.
This is what I told you. We are playing cards here basically. One by one the papers are coming. One by one.
That is the appendix.
No, this is the practice here, Mr. Maninder Singh.
Your Lordship,
You know, we have also seen in 1.5 years.
We try our best. We try our best. We are sorry, but
This is not the way try our best.
my lords, I am sorry. I apologize, but
Sorry is not the answer for this. The way the mess is being created, you have mentioned there, no document on record, nothing.
See what we can.
Yeah.
To give all these notifications one by one.
I'll put them in the same order of compilation and give
It doesn't know it, the private counsel, no, they are mentioned, your lordship is very good.
Just put this in the same order of compilation and give it to the.
Yes, please.
Let's just take a few minutes just to respond only to what your lordships put to me yesterday. On that CTET information bulletin, my lords, I'll put it together with my note so that your lordships can just see it.
The bottom of the story is we should not put any question.
No, my lords, you must.
No, we should not put any question because when new cards will come in, we should only silently hear the case.
Right.
This is the moral of the story. Nothing in petitions, nothing in counter, all cards are coming in the court like this.
My lords, if we had the wisdom and the foresight of mind to imagine all the questions that came from the bench.
We should give the questionnaire first. Then.
No, my lord.
That should be started.
I'm saying it's
Then book should come to us, we prepare a questionnaire and send it.
Lords, it's meant both ways. When we exercise our minds in a different direction, we come up with questions.
You come with
No, that's what I'm saying. The lordship put a question on CTET. We didn't anticipate that CTET comparison is something we should have anticipated. It is our fault. I've just now placed the CTET bulletin, if your lordship can see.
Yes.
It's a page, it starts at page 12. Right, folks? It just come to page 18. Page 18. Page 18, short title, your lordship sees in the middle. Short title. These rules will be called as Central Teacher Eligibility Test Rules 2011. So these are the rules, fellows. We've taken it from the website, in fact. So these are the rules. There's no separate rules. These are the rules. Now it becomes part of this bulletin, which they refer to as the information bulletin. Now in this, if you just come to page number 21, fellows. 21, these left side, nature and standard of questions, your lordships have that. Now, the second bullet point, the test items in language 1 will focus on proficiency related to medium. Next one, the test items in language 2 will focus on elements of language communication, etc. And the third bullet point says language 2 will be language other than language 1. So both languages, and this is the finite list of 20 languages that they have listed. Now, if your lordships will come immediately, that's all I have to show you from the rules. Just please come to page 50 of this compilation. We have taken under TET. Different language. The lordships have that?
that you have said only.
Yes, 50 and 51 is that. Please compare that with 52. 52 is one of them. CTET candidate. So in a CTET, this is the kind of certificate you get. And the language, well, on the right side, if you see, paper 2, you see left side also, language 1 Hindi, language 2 English. There are two separate papers, one for 1 to 5, the second for 6 to 8. So the languages this person has chosen, language 1 is Hindi and language 2 is English. These languages which we have in TET are not even available for them in CTET. Which is why, if your lordships come to page 8 of this note, just see page 8 of the note, I've given that comparison. Your lordships can see that. Well, just finally, on these points, page 8, I've given a comparative table between CTET and JTET with the page numbers. So this is my note from yesterday. I've just expanded it to include this point on CTET JTET comparison.
Yes.
Just two last points. I'll just take half a minute.
Yeah.
One.
Language 2 will be the language other than language 1.
Correct. It's just reproduction, Malad, of what I just read out to you.
Thank you.
That's all. Now, just two last points for us. One, regarding this note that Ms. Arora has just handed up with these points there, I just want to respond to two of them. One, about why we didn't implead all 4 petitions prayers I have here. In all 4 petitions, the primary prayer